Okay, let's unpack this. We are diving into, well, one of the trickiest legal distinctions in criminal law. That is, the razor-thin line that separates genuinely suspicious, uncomfortable behavior from behavior that actually crosses the threshold into criminal assault. For anyone needing to understand how courts analyze, a bad intention versus an actual criminal action, this deep dive is absolutely crucial. Our sources come directly from the Massachusetts case of Commonwealth v. Gorassi. It's quite a shocking case featuring defendant approaching young girls in two separate incidents. What makes this case such a masterclass in legal analysis is that the court found no crime in the first incident, but found sufficient evidence for a serious felony in the second.
Right. And what's fascinating here is how things like proximity, posture, and crucially intent determine everything. We're going to define exactly what constitutes criminal assault and why, mere suspicion is never enough to secure a conviction. The law demands more. It requires an overt act toward the use of force. Our analytical path will model exactly how a court breaks down the elements of assault. We'll focus heavily on that critical distinction between enticement, like a verbal lure, a lie, and the actual use or imminent threat of physical force. We'll use those two conflicting outcomes in Gorassi as our primary test cases. It really highlights the difference.
Okay, good. So to start, when we talk about criminal assault here,
Yeah.
we're talking about an imminent threat, right? What is the foundational rule the courts are looking for, and what specific element is the absolute hurdle for the prosecution?
Right. Criminal assault requires either one of two things. First, an attempted battery. That means intent to use unlawful force plus an overt act toward using it. Or second, placing the victim in reasonable apprehension of an immediate battery. But the critical hurdle, the mountain the prosecutor must climb in cases like this, is proving the element of force or the imminent threat of force. If the defendant relies only on words, however creepy, the assault case fails.
Okay, let's test that rule then. Let's use the first incident, what the court calls the hotel incident.
Huh.
The facts are, frankly, jarring. The defendant followed two girls, ages 8 and 9, for quite a distance, 326 feet down hotel hallways. He caught up to them at a stairwell door, basically a dead end, and asked them to come with him,
Right.
supposedly to show him where the outdoor pool was. He also asked their names and if they wanted to see something pretty. Let's analyze Commonwealth v. Gorassi, the hotel incident. First, what are the legally dispositive facts, the facts that actually matter to the court?
Okay, the essential facts are that extensive following, the 326 feet, the approach at the stairwell, the dead end, and the use of verbal enticement. The pool, something pretty. Crucially, the facts are silent on any physical contact, any express threat, or any impediment of their movement. He didn't block their path.
So the question becomes, even with all those, frankly, terrible facts, why did the law let him off here? What was the core legal issue?
Well, the issue was whether the defendant's actions, the following, the cornering, the questioning, met the legal threshold for criminal assault. Did they evidence an intent to use force or place the girls in reasonable fear of an imminent battery?
What was the primary rule of law the court applied? Can you state the full black-letter rule and break down its testable elements?
Sure, the court applied the rule for criminal assault, specifically focusing on whether there was an attempted battery through threatened force. This rule required the prosecution to prove two key elements. One, an intent by the defendant to use force or threaten force. And two, an overt act reasonably indicating that intention to use force or, importantly, impede movement.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, the intent to use or threaten force?
Right. So the sub-issue for this element was whether using a verbal lure or enticement asking about the pool could count as the necessary force or threat. And the court said definitively no. They explicitly found the defendant sought to overcome the girls by enticement, not by force or threats. There was simply no evidence that he intended to strike them, grab them, or use any kind of physical domination. So element one failed.
Failed. Okay. But wait, isn't following someone for 326 feet, isn't that itself a form of psychological force, especially for an 8-year-old? Why didn't the court see that lengthy pursuit as maybe an attempt to impede movement or at least threaten force implicitly?
And that's exactly why this distinction is so critical and often counterintuitive. The law is very clear. It punishes imminent physical action or the reasonable fear of it, not just bad intent or scary persistence. The court acknowledged his behavior was highly suspicious, obviously, but legally it remained purely verbal and locomotory. He was just walking and talking. Since the intent to apply immediate force failed, the second element, the overt act toward force, also necessarily failed. You can't have an overt act towards force if you don't intend force in the first place.
Okay. And after analyzing the elements, what was the court's final conclusion regarding the hotel incident?
The court concluded that the motion for required findings of not guilty should have been granted. The charges related to this incident had to be dismissed. Following the girls for 326 feet and asking suspicious questions, however unsettling, objectively terrifying for those kids, it simply did not rise to the level of criminal assault because that crucial element of force, or the overt act towards it, was absent.
Right.
This is where we get the fundamental lesson from Gorassi, I think. The 326 feet of persistent, terrifying following meant nothing legally because force was absent. So this raises an important question, a hypothetical. What if the defendant had simply blocked the stairwell door with his body while asking them about the pool, not touching them, just physically blocking their only escape route? Would that minor physical action have changed the legal conclusion?
Oh, absolutely. Yes. That changes everything. The court specifically pointed out there was no evidence that he impeded their movements in any way. Impeding movement, even without touching, is a use of force. It restricts the victim's freedom of movement. You can think of enticement like trying to bait a fish with words, right? But force is dropping the net on it, blocking the door. That's dropping the net. That minor physical restriction likely would have satisfied the force element, transforming mere creepy enticement into actual criminal assault. Makes sense. Okay, now let's turn to the second incident, the library incident. Here, the court reached the opposite conclusion. Sufficient evidence for assault with intent to kidnap. What is the rule for the underlying assault here, which in this case the court found was an attempted battery?
Right. Assault by attempted battery, it's one type of assault requires two things. First, the defendant's intent to commit a battery, meaning an unlawful touching. And second, an overt act. That means a clear physical movement tending directly toward the commission of that battery. It has to be more than just preparation.
Okay, the facts for this incident are, well, significantly more visceral. It involved a 3-year-old girl at a public library. The defendant falsely enticed the girl into a nearby confined room by promising her she could come to see the rabbit inside. A complete lie, obviously. The mother entered the room moments later and saw the girl with her back pressed hard against the wall, crying. The defendant was facing the girl, squatting or half-kneeling, and his hands were about 6 inches from the child. Very close. Let's analyze Commonwealth v. Gorassi, the library incident. What are the key facts here that legally separate this situation from the hotel incident?
Okay, the key facts are the false enticement, that rabbit lie, the victim's very young age, 3 years old, her clear defensive posture back against the wall, crying, and most critically, the defendant's physical proximity and posture, squatting, hands just 6 inches away in a confined space. That proximity, that physical closeness and posture provides the overt physical act that was missing in the hotel incident.
And what was the core legal issue this time?
Well, the issue was twofold, really. First, was the evidence sufficient to infer that the defendant committed an assault, specifically an attempted battery, based on that posture and closeness? And second, if so, was that assault committed with the specific intent to kidnap the child?
What rule of law did the court apply? Please state the full rule for assault with intent to kidnap and break it down into its testable elements.
Sure. The court analyzed the compound crime, assault with intent to kidnap. It's a 2-part crime. This charge requires proof of 1, a common law assault, which was proven here via the attempted battery theory, and 2, the specific intent to kidnap. That means the intent to unlawfully confine or restrain the child.
How did the court apply the first element, the attempted battery? What was the analysis there?
So the sub-issue was whether his physical posture and that 6-inch proximity counted as the necessary overt act toward battery. The court ruled that yes, based on the totality, the girl backed against the wall, the defendant mere inches away, hands reaching toward her, it could reasonably be inferred that the defendant intended to commit a battery, meaning he intended to touch or grab her unlawfully. His physical approach, that close proximity and movement, satisfied the overt act requirement for attempted battery. Element 1, met.
Date. Yes. Okay, understood. Now, what about the second element, the specific intent to kidnap? That seems harder to prove just from his immediate actions.
Right. That's always the challenge with specific intent crimes, proving what was in his head about the future. The sub-issue here was how the Commonwealth proved the intent for the future crime, kidnapping, based on the present actions. The court connected the dots. They linked the evidence of the false enticement, the rabbit lie, which clearly showed an intent to lure her away deceptively, with the attempted battery happening in that confined room. The combination of the attempted use of force, the close approach, and that initial lie used to get her there. That was enough circumstantial evidence for the court to infer the specific intent to illegally restrain the 3-year-old. Element 2 also met T.
Okay, both elements met.
Okay.
And after analyzing both elements, what was the court's final conclusion on this charge?
The court ruled that the defendant's motion for a required finding of not guilty was properly denied. The charges were sustained. The attempt to use force, shown by the extreme physical proximity and posture, combined with that proven false lure, provided a sufficient legal basis for the conviction for assault with intent to kidnap.
So what does this all mean for you, the learner? We've analyzed 2 incidents. Defendant's overall behavior, clearly inappropriate, deeply concerning in both, but only one crossed the criminal threshold. If you are faced with a similar scenario on exam, or just trying to understand this, what is the step-by-step diagnostic checklist we derive from Gorassi?
Right, this case gives us a really clear 4-step path for issue spotting in these kinds of assault situations. 1. Identify the nature of the approach. First ask, is the defendant using mere enticement, verbal persuasion, a ruse, a lie, or are they using actual physical force or a clear threat of imminent force? 2. Test the force element. If the approach relies only on conversation and enticement, like the hotel incident, the assault element fails. Full stop. You must look for an actual use of force, an explicit threat, or, crucially, an impediment of movement. 3. Test attempted battery. If the defendant is physically close, like that 6 inches in the library, and is making an overt, non-consensual movement toward the victim, squatting, reaching, that fulfills the overt act needed for attempted battery. And this is true regardless of whether a ruse was used initially to get them close. The proximity and movement are key. 4. Connect ruse to intent. If a ruse, like the rabbit lie, is present, use that fact, that evidence of deception, to help prove the necessary specific intent for a compound crime, like intent to kidnap, but only after you've already met the initial assault element, the force or attempted battery part. The ruse helps prove why the assault occurred.
That's a great framework. What really stands out here, reflecting on this deep dive, is that the difference between a successful appeal and a sustained felony conviction rested entirely on the distance between the defendant's hand and the victim, measured in inches. Not the 326 feet he spent following her earlier. Inches mattered more than feet.
Exactly. It teaches us that legally, the proximity and immediacy of an overt act towards battery is exponentially more significant than the duration or distance of suspicious or uncomfortable following behavior. Suspicion and persistence, however creepy, aren't the crime. Proximity combined with movement toward battery is the action the law punishes as assault.
We took a deep dive into these really specific legal distinctions between mere suspicion and actual criminal intent. We hope this structured approach gave you a clear, actionable framework for analyzing these complex elements.
Yeah, and if we connect this to the bigger picture, Gorassi is a stark reminder that criminal law is designed to punish demonstrable action and imminent threat, not just bad intentions or uncomfortable conversations that remain solely verbal. There has to be that step towards physical force.
Okay, a final provocative thought for you to consider. Could the hotel incident, the first one, have potentially become an assault if the defendant had chosen to run after the girls for the final 20 feet instead of just walking? Does speed itself change the threat analysis, even without touching or blocking? Something for you to mull over.